I mean, put yourself in their shoes. If you're an employer and you had a nurse that had a drug problem or had diverted or allegedly diverted goods or drugs or something, your exposure out there is huge because lawsuits galore, first of all, and they're going to say, hey, you should have known about this and we're going to sue. Everybody can sue about that. Or a nurse that assaults patients or serially, and that's happened before. You've had serial killer nurses. I mean, that's an extreme example, but you've had nurses that are bent on hurting patients. And those are people that need to be not only put in jail, their license revoked, but severely punished. But this is, that's an extreme example. That's why the employer will do hook or crook to get a confession. Same thing for the police. Most people out there don't know that when you say, I want my lawyer and I want to remain silent, well, in the movies, they leave you alone. In reality, they don't. If you're a good policeman and you're trying to get a confession and you have somebody detained in a room, you'll say, okay, you want a lawyer? First tricks are, you don't need a lawyer. If you get a lawyer, things are going to get more complicated. If you get a lawyer, this is your last chance to help yourself out. If you get a lawyer, you're going to have to be here hours, maybe days waiting for that lawyer. And then they say, what do you expect? And they're going to give you a public defender, some guy who's not even going to look out for your best interest. We're here to help you. And then they put the paper with a pen, write down your statement and what you did. Just write it down. You'll feel better about it. Confess. Well, you know, a lot of people say, I'm not going to buy that. Well, try that when you're handcuffed. Try that when you've had your fingerprints taken. You've been in a jail cell, haven't had a chance to sleep properly. You've been sleep deprived some. You're told when and how you can go to the bathroom. You've been humiliated. You've been changed into scrubs. And you're walking around. Your whole persona, your whole attitude changes. So you have to be strong mentally. And you have to say, again, respectfully, I want to speak with an attorney before I make any admissions or anything, or any statements to you all. But be respectful. If you keep doing that, that will help. Now, you know, that doesn't mean not talk to them at all. Sometimes they try to flatter you or try to bring, you want something to eat? How about a Coke? You know, if you just talk to us, we'll get you something to drink or something. Say, well, I am, you know, thirsty or whatever. Thank you for offering, you know, and I still invoke my right to an attorney and I don't want to make any statements. Oh, we understand. And then they'll come back at you with another technique. They might play good cop, bad cop and say, well, Nurse Y down the hall, we have her. We already arrested her. And we know everything, so tell us everything. And if you lie, you're going to be charged with obstruction of justice. And there's no Nurse Y, possibly. You don't know that. These are the mind games and the interrogation techniques that are used that are very effective. So again, your best and most prudent course of action, if you are accused of a crime, if you're in a station house, and make your phone call, get an attorney, and invoke your right to remain silent. But be courteous. Don't give them attitude. The last thing you want to do, policemen have a lot of discretion how long they can detain you up to a certain point, and you know, they can make your life very hard. So just like getting a pit bull attorney, you want to be able to navigate the system, and this is for years of my experience telling you this. This is very important to keep it in mind. Now, we talked about that. Felonies and misdemeanors. Felonies usually have a lot more consequences. Felonies, you can lose your right to bear arms. You can, you know, a conviction for that. It's almost always an automatic revocation of your license, and you have to reapply. And some people, there's been 10-20% chance, but do get back their license. It depends on the type of felony. Misdemeanor really doesn't involve too much, up to a couple of years in prison if they want to throw the book at you, but it's usually a county jail. It's not a prison or a penitentiary like a felony would get. And it depends. There's state charges and felony charges, federal rather. And federal go by guidelines. The guidelines are advisory, how much time you get. But keep in mind, if you're charged with a federal offense, what I've been telling you throughout the seminar, you need to think about twice as hard. Because over 85% of federal crimes that that the accused is facing, they're going to get prosecuted, they're going to go to jail. It's a high rate in the federal system, and it's about a 50-50 chance usually in the state system. That's why people opt for getting a plea. That's why people opt for sometimes working it out with a prosecutor and getting a lesser. Sometimes you're accused of a felony, you can reduce it down to a misdemeanor. Let's talk about, you know, if you go to trial. You know, The board's been notified, perhaps. We have to just remember that the board can be automatically notified of you being charged or of having a felony. And keep in mind that we've already defined drug diversion, and we've talked about that. That's an example we'll use. Say you were on a drug diversion where you recreationally used the drugs at work for your own use, or maybe sold them, or God forbid, some scenario like that, and you're being charged. So that's the definition of drug diversion as the DEA defines it. And, you may be automatically reported to the board if convicted. And then you have to go through a whole administrative process on that. But let's talk about the day of trial. Let's fast forward. We've got a few minutes left, and I want to underline that. If you are there, charged with a serious crime, they want to throw the book at you, the DA is not willing to bend, you've got a good attorney with a great reputation, say, all right, we're going to try it. And we go through what's called voir dire, jury selection. And that's going in there and asking people, a panel of your peers. More often than not, you want to roll the dice with a jury than a judge, because sometimes, it depends on the judge, Sometimes you're looking at jury, and a lot of people say it's deselection, not selection. That's a little jaded way of looking at it. But the reality is, you don't want somebody on there who wants to fry you and give you 30 years in prison. You want people that are favorable to you. And then the prosecutor is also choosing who they want, who they think is a law and order type. And they ask specific questions to elicit that. How many of you all think that a policeman's testimony is more important or has more weight than the accused? And, and that's how you deselect juror number 1, 2, 3, 4. And then you pick a panel of 12 people and you go there. Day of trial. You do pretrial motions usually then. The suppression motion, sometimes a hearing can be held before then. Suppress a confession if they didn't read you your rights. Suppress if chain of command on some drugs they had that allegedly were yours, but they were not out of your possession. Chain of command, they had to have a chain of evidence. That could be suppressed. We hear our pretrial motions. We go to trial. I do my spiel, the opening statement. Ladies and gentlemen of the jury, I'm proud to represent Nurse X. A little bit about Nurse X. She's been practicing nursing for 15 years. The evidence is going to show that on such and such a date, Nurse X was working on Ward B or whatever, but the evidence is also going to show that there's reasonable doubt that she did not touch any drugs, that she refused a urine test, which was her right, for self-incrimination, and so they don't have any evidence. The DA has no drugs, no connection to her, no witnesses, and once at the end of this trial, you're going to hear all of the evidence. You're going to conclude that she's not guilty. Well, that sounds all well and good. The DA gets his shot at that. Then we call witnesses, and at the end we do closing statements. And I'll do something like, you heard the evidence against Nurse X. The state can't prove their case, or the federal attorney can't prove their case. And I'll tell you why. And then I list out why. And remember what this witness said, and remember what she said, if we decide to put the accused on the stand. And sometimes, it depends on discretion. And at the end, the jury decides. And then at the end, you can appeal a verdict if the worst case scenario, you are convicted. There are appellate remedies. Good luck on appeals. They're hard, but there's a lot of good appeal lawyers out there. A lot of the time, it's a law and order state, and our society is looking at more bars and stiffer sentences is the kind of way we're looking at things nowadays in our society, and it reflects that. We have over 1 million people incarcerated in the United States. In summary, I can only underline that you have to be truthful with your state board, that you have to know your constitutional rights, the right to remain silent, to invoke your right to counsel, and the right also to know all of your constitutional rights about confession. Read up on that, or contact me, or contact the attorney of your choice. If you have any questions about this seminar, this is going to be one of a series of many, hopefully, where the law and nursing overlap. And it's my honor and privilege to talk with my colleagues and educate them a little bit about this in my own small way. Hopefully you can reach me anytime at joe@flotuslawfirm.com or 361-887-8670. Our PowerPoint is also going to be available, incorporated as part of this presentation. And you can also email me, and I'll be glad to send you a copy. Thank you, and God bless.